Here's the latest on the high-profile case, Commonwealth versus Karen Reed. Karen Reed is about to be retried for killing her boyfriend, Boston police officer John O'Keefe, with her SUV and leaving him to die in the snow. The first trial ended with a hung jury, a mistrial. Right now, the parties are in the discovery stage, which means they exchange information with each other. What happened in court recently was very interesting. So Hank Brennan, the special prosecutor, realized that at the last trial, the defense was in flagrant violation of the Massachusetts discovery rules. At the end of that trial, the defense produced two expert witnesses who testified under oath that based on their analysis of Karen's SUV and John O'Keefe's injuries, it didn't appear that he was struck by a car. Now, I discussed their testimony on my podcast. The consensus amongst my guests and many listeners was that the testimony of these two experts was key. I mean, they were not biased and they were believed to be independent, so they carried a lot of weight. We all believed that the experts were hired by the federal government and not the defense. That was significant because it made them independent witnesses. Most expert witnesses are paid for their testimony and they lean one way or the other. Now, these guys took the stand. They said they were not paid and they did not prepare with Karen Reed's defense attorneys prior to trial.
Whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolfe, last name spelled W-O-L-F-E.
So what do you do for a living?
I am the director of accident reconstruction at a company known as ARCA, A-R-C-C-A.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, you walked into court. Have you and I ever met face to face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCA, with the responsibility of doing an accident reconstruction in this case, correct?
Correct.
The person to my left, the female to my left sitting here, you ever seen her before?
Nope.
Do you know who she is?
Yes.
Your analysis, conclusions, and opinions are completely independent, whatever they are. Those analysis, conclusions, and opinions in this case are completely independent of the defense and of the Commonwealth. Have I got that right?
It's based on the evidence, that's correct.
And you're not paid by either side here in this courtroom?
Correct.
Well, Hank Brennan just released a bombshell in court. As it turns out, these witnesses were not telling the truth. In fact, they were paid by the defense for their testimony and even prepared for trial with the defense team. The jurors were led to believe that these experts were unbiased and totally independent. This gave their testimony more credibility. In fact, these witnesses provided the defense with an outline of what to ask them, what they should leave out of their testimony, and they were in fact paid. Take a listen.
What we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolfe, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with the retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. The Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolfe writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in municipal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an assistant, the best I can, to get as much information as I can. We then provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins and the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So, I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. I don't care if the witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I welcome ARCA.
All right, I'm going to take a recess before the